Judgment in the appeal Akerman-Livingstone and Aster Communities Limited.
The issue in this case is whether the courts should adopt the same approach where a tenant facing an eviction claim raises a defence based on discrimination, and specifically disability discrimination under the Equality Act 2010, as it adopts where a tenant raises a defence based on the right to respect for his home, protected by Article 8 of the European Convention on Human Rights. The tenant is a 47-year-old man who is severely disabled by mental ill health. He was housed as a homeless person in a flat in Glastonbury. The local authority decided that they were no longer under a duty to house him, as he had refused an offer of suitable accommodation, and proceedings were taken to evict him. When a public authority brings proceedings to evict a tenant of social housing who has no legal right to remain there, the court can usually dispose summarily of any defence that this is an unjustified interference with the right to respect for his home. The eviction will be justified in order to vindicate the property rights of the social landlord and to enable the local authority to perform their statutory housing duties. The judge in this case adopted the same approach to a defence based on disability discrimination. The Court of Appeal held that he was right to do so, and the tenant appealed to this court. The Supreme Court unanimously holds that the judge should not have adopted the same approach. Rights under the Equality Act are different from and extra to the right to respect for one's home. A disabled tenant cannot be evicted because of something arising in consequence of his disability, unless this is a proportionate means of achieving a legitimate aim. This means that a landlord, whether in the public or the private sector, may have to make allowances for a disabled tenant which he would not have to make for a non-disabled one. Even in social housing, the court cannot assume that the aims of vindicating property rights and enabling the local authority to fulfil their statutory duties will be enough. Summary disposal will not be appropriate if the grounds for disputing the claim appear to be substantial. Therefore, had the situation remained as it was when the judge heard the case in June 2013, the Supreme Court would have allowed the appeal and sent the case back to the County Court for determination. However, as a result of developments since then, it is now inevitable that the claim for possession would succeed. It would be unjust to the landlord and to the freehold owners of the property, and do no kindness to the appellant to prolong matters further. The appeal is therefore dismissed. The court is now adjourned.